that we all understand that public education is just public funds. I'm going to dismiss it right now. I want to share my screen. That we all understand that public education is just public funds. I'm going to dismiss it right now. Here we go. Select. I have to do it this way. Start chatting in minutes. Speech. Here we go.
A. In general, a state is eligible for assistance under this subchapter for a fiscal year if the state submits a plan that provides assurances to the secretary that the state has in effect policies and procedures to ensure that the state meets each of the following conditions. 1. Free appropriate public education. A. In general, a free appropriate public education is available to all children with disabilities residing in the state between the ages of 3 and 21, including children with disabilities who have been suspended or expelled from school. B. Limitation. The obligation to make a free appropriate public education available to all children with disabilities does not apply with respect to children I, age 3 through 5 and 18 through 21 in a state to the extent that its application to those children would be inconsistent with state law or practice or the order of any court respecting the provision of public education to children in those age ranges, and 2, age 18 through 21 to the extent that state law does not require that special education and related services under this subchapter be provided to children with disabilities who, in the educational placement prior to their incarceration in an adult correctional facility, were not actually identified as being a child with a disability under Section 1401 of this title, or 2, did not have an individualized education program under this subchapter. C. State flexibility. A state that provides early intervention services in accordance with subchapter 3 to a child who is eligible for services under Section 1419 of this title is not required to provide such child with a free appropriate public education. 2. Full educational opportunity goal. The state has established the goal of providing full educational opportunity to all children with disabilities in the detailed timetable for accomplishing that goal. 3. Child find. A. In general, all children with disabilities residing in the state, including children with disabilities who are homeless children or are wards of the state, and children with disabilities attending private schools, regardless of the severity of their disabilities, and who are in need of special education and related services, are identified, located, and evaluated, and a practical method is developed and implemented to determine which children with disabilities are currently receiving needed special education and related services. B. Construction. Nothing in this chapter requires that children be classified by their disability so long as each child who has a disability listed in Section 1401 of this title and who, by reason of that disability, needs special education and related services is regarded as a child with a disability under this subchapter. 4. Individualized education program. An individualized education program or an individualized family service plan that meets the requirements of Section 1436D of this title is developed, reviewed, and revised for each child with a disability in accordance with Section 1414D of this title. 5. Least restrictive environment. A. In general.
Where did we stop? I thought we stopped at 5. Well, for whatever reason, then stop reading. So let's just understand what's going on. Let's start here, 5. Because see, people can mess with your signal and stop you from doing whatever they're doing. They think they're doing something big. Big is not what's happening, truly. Ignorance is. And as long as people want to be ignorant and try to oppress me, I'm going to stand up even more. That's all I can say, because pimping ain't easy, and they're not going to start with me.
5. Least restrictive environment. A. In general, to the maximum extent appropriate, children with disabilities, including children in public or private institutions or other care facilities, are educated with children who are not disabled, and special classes, separate schooling, or other removal of children with disabilities from the regular educational environment occurs only when the nature or severity of the disability of a child is such that education in regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. B. Additional requirement. I. In general, a state funding mechanism shall not result in placements that violate the requirements of subparagraph A, and a state shall not use a funding mechanism by which the state distributes funds on the basis of the type of setting in which a child is served that will result in the failure to provide a child with a disability a free appropriate public education according to the unique needs of the child as described in the child's IEP. 2. Assurance. If the state does not have policies and procedures to ensure compliance with Clause I, the state shall provide the Secretary an assurance that the state will revise the funding mechanism as soon as feasible to ensure that such mechanism does not result in such placements. 6. Procedural safeguards. A. In general, children with disabilities and their parents are afforded the procedural safeguards required by Section 1415 of this title. B. Additional procedural safeguards procedures to ensure that testing and evaluation materials and procedures utilized for the purposes of evaluation and placement of children with disabilities for services under this chapter will be selected and administered so as not to be racially or culturally discriminatory. Such materials or procedures shall be provided and administered in the child's native language or mode of communication, unless it clearly is not feasible to do so, and no single procedure shall be the sole criterion for determining an appropriate educational program for a child. 7. Evaluation. Children with disabilities are evaluated in accordance with subsections A through C of Section 1414 of this title. 8. Confidentiality. Agencies in the state comply with Section 1417C of this title relating to the confidentiality of records and information. 9. Transition from Subchapter 3 to preschool programs. Children participating in early intervention programs assisted under Subchapter 3, and who will participate in preschool programs assisted under this subchapter, experience a smooth and effective transition to those preschool programs in a manner consistent with Section 1437A9 of this title. By the third birthday of such a child, an individualized education program or, if consistent with Sections 1414D2B and 1436D of this title, an individualized family service plan has been developed and is being implemented for the child. The local educational agency will participate in transition planning conferences arranged by the designated lead agency under Section 1435A10 of this title. 10. Children in private schools. A. Children enrolled in private schools by their parents. I. In general, to the extent consistent with the number and location of children with disabilities in the state who are enrolled by their parents in private elementary schools and secondary schools in the school district served by a local educational agency. Provision is made for the participation of those children in the program assisted or carried out under this subchapter by providing for such children special education and related services in accordance with the following requirements, unless the Secretary has arranged for services to those children under subsection F. I. Amounts to be expended for the provision of those services, including direct services to parentally placed private school children by the local educational agency, shall be equal to a proportionate amount of federal funds made available under this subchapter. 2. In calculating a proportionate amount of federal funds, The local educational agency, after timely and meaningful consultation with representatives of private schools, as described in Clause 3, shall conduct a thorough and complete child find process to determine the number of parentally placed children with disabilities attending private schools located in the local educational agency. 3. Such services to parentally placed private school children with disabilities may be provided to the children on the premises of private, including religious, schools, to the extent consistent with law. IV. State and local funds may supplement and in no case shall supplant the proportionate amount of federal funds required to be expended under this subparagraph. V. Each local educational agency shall maintain in its records and provide to the state educational agency the number of children evaluated under this subparagraph, the number of children determined to be children with disabilities under this paragraph, and the number of children served under this paragraph. 2. Child find requirement. I. In general, the requirements of paragraph 3 relating to child find shall apply with respect to children with disabilities in the state who are enrolled in private, including religious, elementary schools and secondary schools. 2. Equitable participation. The child find process shall be designed to ensure the equitable participation of parentally placed private school children with disabilities and an accurate count of such children. 3. Activities in carrying out this clause, the local educational agency, or where applicable, the state educational agency, shall undertake activities similar to those activities undertaken for the agency's public school children. IV. Cost. The cost of carrying out this clause, including individual evaluations, may not be considered in determining whether a local educational agency has met its obligations under Clause I. V. Completion period. Such child find process shall be completed in a time period comparable to that for other students attending public schools in the local educational agency. 3. Consultation. To ensure timely and meaningful consultation, a local educational agency, or where appropriate, a state educational agency, shall consult with private school representatives and representatives of parents of parentally placed private school children with disabilities during the design and development of special education and related services for the children, including regarding I. The child find process and how parentally placed private school children suspected of having a disability can participate equitably, including how parents, teachers, and private school officials will be informed of the process. 2. The determination of the proportionate amount of federal funds available to serve parentally placed private school children with disabilities under this subparagraph, including the determination of how the amount was calculated. 3. The consultation process among the local educational agency, private school officials, and representatives of parents of parentally placed private school children with disabilities, including how such process will operate throughout the school year to ensure that parentally placed private school children with disabilities identified through the child find process can meaningfully participate in special education and related services. IV. How, where, and by whom special education and related services will be provided for parentally placed private school children with disabilities, including a discussion of types of services, including direct services and alternate service delivery mechanisms, how such services will be apportioned if funds are insufficient to serve all children, and how and when these decisions will be made, and how, if the local educational agency disagrees with the views of the private school officials on the provision of services or the types of services, whether provided directly or through a contract, the local educational agency shall provide to the private school officials a written explanation of the reasons why the local educational agency chose not to provide services directly or through a contract. IV. Written affirmation when timely and meaningful consultation, as required by Clause 3, has occurred. The local educational agency shall obtain a written affirmation signed by the representatives of participating private schools, and if such representatives do not provide such affirmation within a reasonable period of time, the local educational agency shall forward the documentation of the consultation process to the state educational agency. V. Compliance. I. In general, a private school official shall have the right to submit a complaint to the state educational agency that the local educational agency did not engage in consultation that was meaningful and timely, or did not give due consideration to the views of the private school official. 2. Procedure. If the private school official wishes to submit a complaint, the official shall provide the basis of the noncompliance with this subparagraph by the local educational agency to the state educational agency, and the local educational agency shall forward the appropriate documentation to the state educational agency. If the private school official is dissatisfied with the decision of the state educational agency, such official may submit a complaint to the secretary by providing the basis of the noncompliance with this subparagraph by the local educational agency to the secretary, and the state educational agency shall forward the appropriate documentation to the secretary. via provision of equitable services, directly or through contracts. The provision of services pursuant to this subparagraph shall be provided, A, by employees of a public agency, or B, through contract by the public agency with an individual, association, agency, organization, or other entity. 2. Secular, neutral, non-ideological special education and related services provided to parentally placed private school children with disabilities, including materials and equipment, shall be secular, neutral, and non-ideological. VA. Public control of funds. The control of funds used to provide special education and related services under this subparagraph, entitled to materials, equipment, and property purchased with those funds, shall be in a public agency for the uses and purposes provided in this chapter, and a public agency shall administer the funds and property. B. Children placed in, or referred to, private schools by public agencies. In general, children with disabilities in private schools and facilities are provided special education and related services in accordance with an individualized education program at no cost to their parents, if such children are placed in, or referred to, such schools or facilities by the state or appropriate local educational agency as the means of carrying out the requirements of this subchapter or any other applicable law requiring the provision of special education and related services to all children with disabilities within such state. 2. Standards. In all cases described in Clause I, the state educational agency shall determine whether such schools and facilities meet standards that apply to state educational agencies and local educational agencies, and that children so served have all the rights the children would have if served by such agencies. C. Payment for education of children enrolled in private schools without consent of or referral by the public agency. In general, subject to subparagraph A. This subchapter does not require a local educational agency to pay for the cost of education, including special education and related services, of a child with a disability at a private school or facility if that agency made a free appropriate public education available to the child and the parents elected to place the child in such private school or facility. 2. Reimbursement for private school placement if the parents of a child with a disability who previously received special education and related services under the authority of a public agency enroll the child in a private elementary school or secondary school without the consent of or referral by the public agency. A court or a hearing officer may require the agency to reimburse the parents for the cost of that enrollment if the court or hearing officer finds that the agency had not made a free appropriate public education available to the child in a timely manner prior to that enrollment. 3. Limitation on reimbursement. The cost of reimbursement described in Clause 2 may be reduced or denied, if A. At the most recent IEP meeting that the parents attended prior to removal of the child from the public school, the parents did not inform the IEP team that they were rejecting the placement proposed by the public agency to provide a free appropriate public education to their child, including stating their concerns and their intent to enroll their child in a private school at public expense, or BB 10 business days, including any holidays that occur on a business day, prior to the removal of the child from the public school, the parents did not give written notice to the public agency of the information described in item AA. 2. If, prior to the parent's removal of the child from the public school, the public agency informed the parents, through the notice requirements described in Section 1415b3 of this title, of its intent to evaluate the child, including a statement of the purpose of the evaluation that was appropriate and reasonable, but the parents did not make the child available for such evaluation, or 3. Upon a judicial finding of unreasonableness with respect to actions taken by the parents. IV. Exception notwithstanding the notice requirement in Clause 3I, the cost of reimbursement, I, shall not be reduced or denied for failure to provide such notice if AA, the school prevented the parent from providing such notice, BB, the parents had not received notice, pursuant to Section 1415 of this title, of the notice requirement in Clause 3I, or CC, compliance with Clause 3I would likely result in physical harm to the child, and 2, may, in the discretion of a court or hearing officer, not be reduced or denied for failure to provide such notice if AA, the parent is illiterate or cannot write in English, or BB, compliance with Clause 3I would likely result in serious emotional harm to the child. 11. State educational agency responsible for general supervision. A. In general, the state educational agency is responsible for ensuring that I. The requirements of this subchapter are met. 2. All educational programs for children with disabilities in the state, including all such programs administered by any other state agency or local agency, I, are under the general supervision of individuals in the state who are responsible for educational programs for children with disabilities, and 2. Meet the educational standards of the state educational agency, and 3. In carrying out this subchapter with respect to homeless children, the requirements of Subtitle B of Title VII of the McKinney-Vento Homeless Assistance Act, 42 U.S.C. 11431, et sec., are met. B. Limitation subparagraph A shall not limit the responsibility of agencies in the state other than the state educational agency to provide or pay for some or all of the costs of free appropriate public education for any child with a disability in the state. C. Exception notwithstanding subparagraphs A and B, the governor or another individual pursuant to state law, consistent with state law, may assign to any public agency in the state the responsibility of ensuring that the requirements of this subchapter are met with respect to children with disabilities who are convicted as adults under state law and incarcerated in adult prisons. 12. Obligations related to and methods of ensuring services. A. Establishing responsibility for services. The chief executive officer of a state or designee of the officer shall ensure that an interagency agreement or other mechanism for interagency coordination is in effect between each public agency described in subparagraph B and the state educational agency in order to ensure that all services described in subparagraph B I that are needed to ensure a free appropriate public education are provided, including the provision of such services during the pendency of any dispute under Clause 3. Such agreement or mechanism shall include the following: I. Agency financial responsibility and identification of or method for defining the financial responsibility of each agency for providing services described in subparagraph B I to ensure a free appropriate public education to children with disabilities, provided that the financial responsibility of each public agency described in subparagraph B, including the state Medicaid agency and other public insurers of children with disabilities, shall precede the financial responsibility of the local educational agency or the state agency responsible for developing the child's IEP. 2. Conditions and terms of reimbursement. The conditions, terms, and procedures under which a local educational agency shall be reimbursed by other agencies. 3. Interagency disputes procedures for resolving interagency disputes, including procedures under which local educational agencies may initiate proceedings under the agreement or other mechanism to secure reimbursement from other agencies or otherwise implement the provisions of the agreement or mechanism. IV. Coordination of services, procedures, policies, and procedures for agencies to determine and identify the interagency coordination responsibilities of each agency to promote the coordination and timely and appropriate delivery of services described in subparagraph B(I). B. Obligation of public agency. I. In general, if any public agency other than an educational agency is otherwise obligated under federal or state law or assigned responsibility under state policy pursuant to subparagraph A, to provide or pay for any services that are also considered special education or related services, such as, but not limited to, services described in Section 1401(1) relating to assistive technology devices, 1401(2) relating to assistive technology services, 1401(26) relating to related services, 1401(33) relating to supplementary aids and services, and 1401(34) of this title relating to transition services that are necessary for ensuring a free appropriate public education to children with disabilities within the state. Such public agency shall fulfill that obligation or responsibility, either directly or through contract or other arrangement pursuant to subparagraph A or an agreement pursuant to subparagraph C. 2. Reimbursement for services by public agency. If a public agency other than an educational agency fails to provide or pay for the special education and related services described in Clause I, the local educational agency or state agency responsible for developing the child's IEP shall provide or pay for such services to the child. Such local educational agency or state agency is authorized to claim reimbursement for the services from the public agency that failed to provide or pay for such services, and such public agency shall reimburse the local educational agency or state agency pursuant to the terms of the interagency agreement or other mechanism described in subparagraph A(I) according to the procedures established in such agreement pursuant to subparagraph A(2). C. Special rule. The requirements of subparagraph A may be met through I. State statute or regulation. 2. Signed agreements between respective agency officials that clearly identify the responsibilities of each agency relating to the provision of services. Or 3. Other appropriate written methods as determined by the Chief Executive Officer of the state or designee of the officer and approved by the Secretary. 13. Procedural requirements relating to local educational agency eligibility. The state educational agency will not make a final determination that a local educational agency is not eligible for assistance under this subchapter without first affording that agency reasonable notice and an opportunity for a hearing. 14. Personnel qualifications. A. In general, the state educational agency has established and maintains qualifications to ensure that personnel necessary to carry out this subchapter are appropriately and adequately prepared and trained, including that those personnel have the content knowledge and skills to serve children with disabilities. B. Related services personnel and paraprofessionals. The qualifications under subparagraph A include qualifications for related services personnel and paraprofessionals that I. Are consistent with any state-approved or state-recognized certification, licensing, registration, or other comparable requirements that apply to the professional discipline in which those personnel are providing special education or related services. 2. Ensure that related services personnel who deliver services in their discipline or profession meet the requirements of Clause I and have not had certification or licensure requirements waived on an emergency, temporary, or provisional basis. And 3. Allow paraprofessionals and assistants who are appropriately trained and supervised in accordance with state law, regulation, or written policy in meeting the requirements of this subchapter to be used to assist in the provision of special education and related services under this subchapter to children with disabilities. C. Qualifications for special education teachers. The qualifications described in subparagraph A shall ensure that each person employed as a special education teacher in the state who teaches elementary school, middle school, or secondary school has obtained full state certification as a special education teacher, including participating in an alternate route to certification as a special educator, if such alternate route meets minimum requirements described in Section 2005.56A2 of Title 34, Code of Federal Regulations, as such section was in effect on November 28, 2008, or passed the state special education teacher licensing examination, and holds a license to teach in the state as a special education teacher, except with respect to any teacher teaching in a public charter school who shall meet the requirements set forth in the state's public charter school law. 2. Has not had special education certification or licensure requirements waived on an emergency, temporary, or provisional basis, and 3. Holds at least a bachelor's degree. 1D. Policy in implementing this section. A state shall adopt a policy that includes a requirement that local educational agencies in the state take measurable steps to recruit, hire, train, and retain personnel who meet the applicable requirements described in this paragraph to provide special education and related services under this subchapter to children with disabilities. E. Rule of construction notwithstanding any other individual right of action that a parent or student may maintain under this subchapter, nothing in this paragraph shall be construed to create a right of action on behalf of an individual student for the failure of a particular state educational agency or local educational agency staff person to meet the applicable requirements described in this paragraph, or to prevent a parent from filing a complaint about staff qualifications with the state educational agency as provided for under this subchapter. 15. Performance goals and indicators. The state A has established goals for the performance of children with disabilities in the state that promote the purposes of this chapter, as stated in Section 1400D of this title. 2. Are the same as the state's long-term goals and measurements of interim progress for children with disabilities under Section 6311 C4AI of this title. 3. Address graduation rates and dropout rates, as well as such other factors as the state may determine, and IV are consistent to the extent appropriate with any other goals and standards for children established by the state. B has established performance indicators the state will use to assess progress toward achieving the goals described in subparagraph A, including measurements of interim progress for children with disabilities under Section 6311 C4AI of this title, and C will annually report to the Secretary and the public on the progress of the state and of children with disabilities in this state toward meeting the goals established under subparagraph A, which may include elements of the reports required under Section 6311 H of this title. 16. Participation in assessments. A. In general, all children with disabilities are included in all general state and district-wide assessment programs, including assessments described under Section 6311 of this title, with appropriate accommodations and alternate assessments where necessary and as indicated in their respective individualized education programs. B. Accommodation guidelines to the state or, in the case of a district-wide assessment, the local educational agency has developed guidelines for the provision of appropriate accommodations. C. Alternate assessments. In general, the state or, in the case of a district-wide assessment, the local educational agency has developed and implemented guidelines for the participation of children with disabilities in alternate assessments for those children who cannot participate in regular assessments under subparagraph A, with accommodations as indicated in their respective individualized education programs. 2. Requirements for alternate assessments. The guidelines under Clause I shall provide for alternate assessments that I are aligned with the challenging state academic content standards under Section 6311B1 of this title and alternate academic achievement standards under Section 6311B1E of this title, and 2, if the state has adopted alternate academic achievement standards permitted under Section 6311B1E of this title, measure the achievement of children with disabilities against those standards. 3. Conduct of alternate assessments. The state conducts the alternate assessments described in this subparagraph. D. Reports the state educational agency, or, in the case of a district-wide assessment, the local educational agency makes available to the public and reports to the public with the same frequency and in the same detail as it reports on the assessment of non-disabled children, the following: I, the number of children with disabilities participating in regular assessments, and the number of those children who were provided accommodations in order to participate in those assessments. 2, the number of children with disabilities participating in alternate assessments described in subparagraph C2I. 3, the number of children with disabilities participating in alternate assessments described in subparagraph C22. IV, the performance of children with disabilities on regular assessments and on alternate assessments, if the number of children with disabilities participating in those assessments is sufficient to yield statistically reliable information, and reporting that information will not reveal personally identifiable information about an individual student, compared with the achievement of all children, including children with disabilities, on those assessments. E. Universal design. The state educational agency, or, in the case of a district-wide assessment, the local educational agency shall, to the extent feasible, use universal design principles in developing and administering any assessments under this paragraph. 17. Supplementation of state, local, and other federal funds. A. Expenditures. Funds paid to a state under this subchapter will be expended in accordance with all the provisions of this subchapter. B. Prohibition against commingling. Funds paid to a state under this subchapter will not be commingled with state funds. C. Prohibition against supplantation and conditions for waiver by Secretary except as provided in Section 1413 of this title. Funds paid to a state under this subchapter will be used to supplement the level of federal, state, and local funds, including funds that are not under the direct control of state or local educational agencies, expended for special education and related services provided to children with disabilities under this subchapter, and in no case to supplant such federal, state, and local funds, except that, where the state provides clear and convincing evidence that all children with disabilities have available to them a free appropriate public education, the Secretary may waive, in whole or in part, the requirements of this subparagraph if the Secretary concurs with the evidence provided by the state. 18. Maintenance of state financial support. A. In general, the state does not reduce the amount of state financial support for special education and related services for children with disabilities, or otherwise made available because of the excess costs of educating those children, below the amount of that support for the preceding fiscal year. B. Reduction of funds for failure to maintain support. The Secretary shall reduce the allocation of funds under Section 1411 of this title for any fiscal year following the fiscal year in which the state fails to comply with the requirement of subparagraph A by the same amount by which the state fails to meet the requirement. C. Waivers for exceptional or uncontrollable circumstances. The Secretary may waive the requirement of subparagraph A for a state for one fiscal year at a time if the Secretary determines that granting the waiver would be equitable due to exceptional or uncontrollable circumstances such as a natural disaster or a precipitous and unforeseen decline in the financial resources of the state, or 2, the state meets the standard in paragraph 17C for a waiver of the requirement to supplement and not to supplant funds received under this subchapter. D. Subsequent years if, for any year, a state fails to meet the requirement of subparagraph A, including any year for which the state is granted a waiver under subparagraph C, The financial support required of the state in future years under subparagraph A shall be the amount that would have been required in the absence of that failure and not the reduced level of the state's support. 19. Public participation prior to the adoption of any policies and procedures needed to comply with this section, including any amendments to such policies and procedures. The state ensures that there are public hearings, adequate notice of the hearings, and an opportunity for comment available to the general public, including individuals with disabilities and parents of children with disabilities. 20. Rule of construction and complying with paragraphs 17 and 18. A state may not use funds paid to it under this subchapter to satisfy state law mandated funding obligations to local educational agencies, including funding based on student attendance or enrollment, or inflation. 21. State Advisory Panel. A. In general, the state has established and maintains an advisory panel for the purpose of providing policy guidance with respect to special education and related services for children with disabilities in the state. B. Membership. Such advisory panel shall consist of members appointed by the governor or any other official authorized under state law to make such appointments, be representative of the state population, and be composed of individuals involved in, or concerned with, the education of children with disabilities, including I. Parents of children with disabilities, ages birth through 26, 2. Individuals with disabilities, 3. Teachers, IV, representatives of institutions of higher education that prepare special education and related services personnel, v. State and local education officials, including officials who carry out activities under Subtitle B of Title VII of the McKinney-Vento Homeless Assistance Act, 42 U.S.C. 11431, et sec. VI. Administrators of programs for children with disabilities, VA. Representatives of other state agencies involved in the financing or delivery of related services to children with disabilities, VI. Representatives of private schools and public charter schools, X. Not less than one representative of a vocational, community, or business organization concerned with the provision of transition services to children with disabilities, X. A representative from the state child welfare agency responsible for foster care, and she. Representatives from the state juvenile and adult corrections agencies. C. Special rule. A majority of the members of the panel shall be individuals with disabilities or parents of children with disabilities, ages birth through 26. D. Duties. The advisory panel shall I. Advise the state educational agency of unmet needs within the state in the education of children with disabilities. 2. Comment publicly on any rules or regulations proposed by the state regarding the education of children with disabilities. 3. Advise the state educational agency in developing evaluations and reporting on data to the Secretary under Section 1418 of this title. IV. Advise the state educational agency in developing corrective action plans to address findings identified in federal monitoring reports under this subchapter. And V. Advise the state educational agency in developing and implementing policies relating to the coordination of services for children with disabilities. 22. Suspension and expulsion rates. A. In general, the state educational agency examines data, including data disaggregated by race and ethnicity, to determine if significant discrepancies are occurring in the rate of long-term suspensions and expulsions of children with disabilities, I. among local educational agencies in the state, or 2. compared to such rates for non-disabled children within such agencies. B. Review and revision of policies. If such discrepancies are occurring, the state educational agency reviews and, if appropriate, revises or requires the affected state or local educational agency to revise its policies, procedures, and practices relating to the development and implementation of IEPs, the use of positive behavioral interventions and supports, and procedural safeguards to ensure that such policies, procedures, and practices comply with this chapter. 23. Access to instructional materials. A. In general, the state adopts the National Instructional Materials Accessibility Standard for the purposes of providing instructional materials to blind persons or other persons with print disabilities in a timely manner after the publication of the National Instructional Materials Accessibility Standard in the Federal Register. B. Rights of state educational agency. Nothing in this paragraph shall be construed to require any state educational agency to coordinate with the National Instructional Materials Access Center. If a state educational agency chooses not to coordinate with the National Instructional Materials Access Center, such agency shall provide an assurance to the Secretary that the agency will provide instructional materials to blind persons or other persons with print disabilities in a timely manner. C. Preparation and delivery of files. If a state educational agency chooses to coordinate with the National Instructional Materials Access Center, not later than 2 years after December 3, 2004, the agency, as part of any print instructional materials adoption process, procurement contract, or other practice or instrument used for purchase of print instructional materials, shall enter into a written contract with the publisher of the print instructional materials to I. Require the publisher to prepare and, on or before delivery of the print instructional materials, provide to the National Instructional Materials Access Center electronic files containing the contents of the print instructional materials using the National Instructional Materials Accessibility Standard, or 2. Purchase instructional materials from the publisher that are produced in, or may be rendered in, specialized formats. D. Assistive technology. In carrying out this paragraph, the state educational agency, to the maximum extent possible, shall work collaboratively with the state agency responsible for assistive technology programs. E. Definitions. In this paragraph, I. National Instructional Materials Access Center. The term National Instructional Materials Access Center means the center established pursuant to Section 1474E of this title. 2. National Instructional Materials Accessibility Standard. The term National Instructional Materials Accessibility Standard has the meaning given to the term in Section 1474E3A of this title. 3. Specialized formats. The term specialized formats has the meaning given to the term in Section 1474E3D of this title. 24. Over identification and disproportionality. The state has an effect consistent with the purposes of this chapter and with Section 1418D of this title, policies and procedures designed to prevent the inappropriate over-identification or disproportionate representation by race and ethnicity of children as children with disabilities, including children with disabilities with a particular impairment described in Section 1401 of this title. 25. Prohibition on mandatory medication. A. In general, the state educational agency shall prohibit state and local educational agency personnel from requiring a child to obtain a prescription for a substance covered by the Controlled Substances Act, 21 U.S.C. 801 et sec. As a condition of attending school, receiving an evaluation under subsection A or C of Section 1414 of this title, or receiving services under this chapter. B. Rule of construction. Nothing in subparagraph A shall be construed to create a federal prohibition against teachers and other school personnel consulting or sharing classroom-based observations with parents or guardians regarding a student's academic and functional performance or behavior in the classroom or school, or regarding the need for evaluation for special education or related services under paragraph 3. B. State educational agency as provider of free appropriate public education or direct services. If the state educational agency provides free appropriate public education to children with disabilities, or provides direct services to such children, such agency, 1, shall comply with any additional requirements of Section 1413A of this title, as if such agency were a local educational agency, and 2, may use amounts that are otherwise available to such agency under this subchapter to serve those children without regard to Section 1413A2AI of this title relating to excess costs. C. Exception for prior state plans. 1. In general, if a state has on file with the Secretary policies and procedures that demonstrate that such state meets any requirement of subsection A, including any policies and procedures filed under this subchapter as in effect before the effective date of the Individuals with Disabilities Education Improvement Act of 2004, the Secretary shall consider such state to have met such requirement for purposes of receiving a grant under this subchapter. 2. Modifications made by state subject to paragraph 3. An application submitted by a state in accordance with this section shall remain in effect until the state submits to the Secretary such modifications as the state determines necessary. This section shall apply to a modification to an application to the same extent and in the same manner as this section applies to the original plan. 3. Modifications required by the Secretary if, after the effective date of the Individuals with Disabilities Education Improvement Act of 2004, the provisions of this chapter are amended, or the regulations developed to carry out this chapter are amended, there is a new interpretation of this chapter by a federal court or a state's highest court, or there is an official finding of noncompliance with federal law or regulations, then the Secretary may require a state to modify its application only to the extent necessary to ensure the state's compliance with this subchapter. D. Approval by the Secretary. 1. In general, if the Secretary determines that a state is eligible to receive a grant under this subchapter, the Secretary shall notify the state of that determination. 2. Notice and hearing. The Secretary shall not make a final determination that a state is not eligible to receive a grant under this subchapter until after providing the state A. with reasonable notice, and B. with an opportunity for a hearing. E. Assistance under other federal programs. Nothing in this chapter permits a state to reduce medical and other assistance available, or to alter eligibility, under Titles V and XIX of the Social Security Act, 42 U.S.C. 701 at SEQ, 1396 at SEC, with respect to the provision of a free appropriate public education for children with disabilities in the state. F. Bypass for children in private schools. 1. In general, if, on December 2nd, 1983, a state educational agency was prohibited by law from providing for the equitable participation in special programs of children with disabilities enrolled in private elementary schools and secondary schools as required by subsection A-10A, or if the Secretary determines that a state educational agency, local educational agency, or other entity has substantially failed or is unwilling to provide for such equitable participation, then the Secretary shall, notwithstanding such provision of law, arrange for the provision of services to such children through arrangements that shall be subject to the requirements of such subsection. 2. Payments. A. Determination of amounts. If the Secretary arranges for services pursuant to this subsection, the Secretary, after consultation with the appropriate public and private school officials, shall pay to the provider of such services for a fiscal year an amount per child that does not exceed the amount determined by dividing I. the total amount received by the state under this subchapter for such fiscal year by 2. the number of children with disabilities served in the prior year, as reported to the Secretary by the state under Section 1418 of this title. B. Withholding of certain amounts pending final resolution of any investigation or complaint that may result in a determination under this subsection. The Secretary may withhold from the allocation of the affected state educational agency the amount the Secretary estimates will be necessary to pay the cost of services described in subparagraph A. C. Period of payments. The period under which payments are made under subparagraph A shall continue until the Secretary determines that there will no longer be any failure or inability on the part of the state educational agency to meet the requirements of subsection A-10A. 3. Notice and hearing. A. In general, the Secretary shall not take any final action under this subsection until the state educational agency affected by such action has had an opportunity, for not less than 45 days, after receiving written notice thereof, to submit written objections and to appear before the Secretary or the Secretary's designee to show cause why such action should not be taken. B. Review.
Oh my goodness, it stopped again. I just can't believe these folks. They're so busy. They are really busy. I'm not gonna do this. I'm gonna do this. This is almost over. There we go. So push it back up here. Okay. See, this is a responsibility of the state. The state has obligations. Where is speech? There it is. There we go.
B. Review of action if a state educational agency is dissatisfied with the Secretary's final action after a proceeding under subparagraph A. Such agency may, not later than 60 days after notice of such action, file with the United States Court of Appeals for the circuit in which such state is located a petition for review of that action. A copy of the petition shall be forthwith transmitted by the clerk of the court to the Secretary. The Secretary thereupon shall file in the court the record of the proceedings on which the Secretary based the Secretary's action, as provided in Section 2112 of Title 28. C. Review of findings of fact. The findings of fact by the Secretary, if supported by substantial evidence, shall be conclusive, but the court, for good cause shown, may remand the case to the Secretary to take further evidence, and the Secretary may thereupon make new or modified findings of fact and may modify the Secretary's previous action, and shall file in the court the record of the further proceedings. Such new or modified findings of fact shall likewise be conclusive if supported by substantial evidence. D. Jurisdiction of Court of Appeals. Review by United States Supreme Court upon the filing of a petition under subparagraph B. The United States Court of Appeals shall have jurisdiction to affirm the action of the Secretary or to set it aside, in whole or in part. The judgment of the court shall be subject to review by the Supreme Court of the United States upon certiorari or certification as provided in Section 1254 of Title 28. Pub. L. 91-230, Title VI, Paragraph 612, as added Pub. L. 108-446, Title A, Paragraph 101, December 3rd, 2004, 118 Stat. 2676, amended Pub. L. 114-95, Title IX, Paragraph 9214 D2, 9215 SS3, December 10th, 2015, 129 Stat. 2164, 2182. U.S. Code Toolbox Law about articles from WEX Table of Popular Names Parallel Table of Authorities.
Okay, I'll stop this year. And so, you really guys understand. I'm just trying to understand what we're doing here in America, as they've not went back and supported the states in ensuring adequacy and adequacy happen. I'm gonna go and look for, what I was listening to today was how office, what Clark County is doing in regards to public schools. And they're just rushing in there and arresting those kids and for allegations, but they got all kind of dysfunction going on in there because the kids are just not learning. And there's just so much guidance given by the federal government that Nevada just doesn't even adhere to. So really, state eligibility. Is that one I just read? I don't know. Let's just look. Let me just share the screen one more time and go here and share that because I want to go here. Is that the one I want to go to? No. Let's see. Where's that one? Nope. Where is this? Nevada's discipline laws. No, I don't even want to. That's so out of control right there. I don't want that one though. What is that one? Not that one. Oh, that's where I couldn't stream on Facebook. That's just bullshit because Facebook, I'm going to show you what happened. Since I'm sharing the screen, I want to go to my page. Where is me? Whoa. There we go. And so, look, see how it says my account is restricted? It is. It's just restricted. And then when I go here, I want to know why it was restricted. It says your account for multiple restrictions on your account. And so April the 16th, they said I can go live. Why? Because they're still using this one from May the 6th, 2021. But this original post was from way back in 2018 or something like that. More than 2018. It was way back in 2008 or something. I can't even remember. Somebody else posted it and I shared. And then it says, this was Roland Martin's. I shared Roland Martin's shot in the back of the head. I shared Roland's stuff. And so I get restricted. And then let's see. And then when you click here, we understand that it was a mistake. So it's why we didn't restrict you. They restricted me. You see that? My account is still restricted. They're talking about why they didn't restrict me. I don't care. Really, I really don't care because they don't own me. And I'm not owned by America either. I'm just an American citizen. But this is the same thing. And they still keep going back to this one. Well, let's just see that one initially. Okay. Where are we? It doesn't even show the original one, does it? I wouldn't take that. I wouldn't take this post down. And because it was on my account from a long time ago. It wasn't, I reshared it in 2021. I don't care what these people say. They can't stop me from being me, that's for sure. I'm gonna go to my page and I'm gonna go to, I think I'm gonna go to my groups. Here we go. Why I think they restricted my accounts because I came to this parent group right here and I shared that there's going to be a conference and it's going to be a webinar. And I encourage parents to participate. And then that's when I got the damn restriction. I really don't care. It's not going to stop me from sharing in the group. What they're going to tell me is I can't share in their streams. And that's not public money, boo. You can't restrict people from participating in the public. I promise you that. And I'm going to stop the share and just say, in America, who are you? And what is it that you do? I'm not sure because all the public services are just broken. And it seems like crime is big money here because I remember when I first moved here to Clark County. Well, somebody under Cox thought that they were being funny and they went through every computer that I had and removed the network adapter. And I said, really? Even the new one, this one that I'm on, someone took the network adapter so I couldn't connect to my home Wi-Fi. And I said, that's just bullshit. So I called them up and let them know that they were going to get that $400 if they didn't get off my ass. Well, then before it was time to get the payday. And I filed, of course, I filed with the Fair Trade Commission and I filed with the FCC. And it doesn't matter because Nevada is a states' rights state and you don't understand. They have an Office of Inspector General. Let me show you what happens. Well, I'm going to share the screen one more time. When you go to this website, And I said, oh, they have an Office of Inspector General? And you say, oh, I want to push on this site. And I did. And then when I tried to figure out what was happening, I wanted to contact that person. And then, oh, well, they don't have anything that they're actually doing. Let's just put it that way. Criminal investigations pertain to both persons and prisoners. They're supposed to be doing much more. I mean, when it comes to public education, and medical fraud and fraud. Oh, the Silver State inquiries. What is this? Silver State Industries, garment manufacturing, printing. I believe this is the prisoners. Because this is not public. This is crazy. What is this? About. Let's look. It's fun to wrench. Oh, this is interesting. Shall we all understand what's going on? The Northern Nevada Correctional Center Stewart Conservation Camp Saddle Horse Training Program is cooperative partnership between the Bureau of Land Management and the Nevada Department of Corrections and the Nevada Department of Agriculture. And it trains wild horses for adoption and whatever. And it just goes on to what they're doing. They got a ranch out there and they got auto shop. Look how they're doing that work out there in the penitentiary, y'all. Upholstery. Ooh, somebody's getting over. Let's look at their furniture shop. No, let's look at their garment shop, shall we? Oh, I think these are just uniforms, don't you? Call for manufacturing. Ooh, yes, manufacturing online. Y'all all need to understand what this is all about. Let's go home, shall we? Does it have any? Okay, let's go to their page. The CDC. The Department of Corrections. Now, we just jumped from, let's go back, because I don't even think y'all really paying attention how they make money in the penitentiary and how these young people are going to the penitentiary for a very long time and they still come out, they're still unemployable. Can we just do a search on public education? I don't even think they have a search on this page. How amazing. Where does the money go? Money. You get real money. Look at what they're producing. Look at that. That's beautiful, isn't it? Prisoners are making, prison industries online, boo. Understand they sell to their own businesses. A furniture shop. It's real. Life is real. Stop to share. I have to look up one more thing. Section 1465B1. Let me just stop to share. Start to share one more time. This ought to be good. I don't know if I did this one before. I want to see it. I want to download it. Oh, yeah. See what I'm there. I want to find it. Show in the finder because as soon as it gets done. I got to find it in the preview. Open system there. Yeah, that's it. Then we got to go up here. Oh, I'm looking for one thing. What am I looking for? ISPIORNA. Okay. Nevada. NEVA. Okay. I'm stuck to share, make sure I'm still sharing. Because I know I'm still live. And I'm live. And I'm tired, but it doesn't make any difference. Share the screen. Here we go. I think this is it. Okay. No. So that way I'm going to share. Yes. Okay. See, Nevada. And what is Nevada reporting? The percentage of population of birth through 2 that are served under IDEA Part C. And what is that? 2.1, 3.2, 1.1, 51.6. The total, the percent changed. And I don't even know how they do this, but I just want to see Nevada's scores and what Nevada's saying, because Nevada never provides any real information. These are just numbers. We're looking at Nevada's numbers. And really, they're just comparing Nevada with all of the other states. Determine Part B requirements by federal. Now, see that? What does this say? It says, I'm going to let y'all read it. I'm going to have to read this right here. Right here. Where is my spelling? It's like, where's my spelling bee? It's all hidden over here. There we go. Oh, come on, y'all, move. There we go. Speech.
Determination status. In June 2020, the Secretary issued determination letters on the implementation of IDEA to each state educational agency, SEA, for Part B, and to each state lead agency for Part 100. Exhibit 87 shows the results of the FFY 2018 determinations by state for Part B. Exhibit 88 shows the results for Part 100. Exhibit 87. States determined in 2020 to have met IDEA Part B requirements by determination status. Federal fiscal year 2018.
Okay, so they've got Nevada here, right here. Needs 2 or more consecutive years of what? Needs assistance. Do you understand what I'm saying? And then determine the Part C money needs assistance. You see that? In 2018, they needed assistance. And so are they getting more assistance? I don't think so. What does this one say? The number of percentage of population of infants and toddlers through birth. I mean, look, 3,000, such low numbers. Such low numbers because only a few children benefit here. And that's the people with money, boo. Money is everything. My nose is itching. Let me see if I can get this scooted over a little bit more. Yeah, there we go. Okay, I just moved this whole window. There we go. Oh, my nose is really itchy. No. What's this last one? It just doesn't make a whole lot of sense because it's just mostly, I'm going to stop this year. Mostly it's just the numbers. And Nevada's a needs assessment. They need assistance for the Part B money and they need assistance for the Part C money. And guess what? That's just not free money. I said it's not free money. So people are going to find out that perhaps we live in America and we're all Americans. And regardless if you restrict me on Facebook because you're getting ready to do your legislative trials, your conversations publicly, I'm still going to record those meetings and share them. And if I don't record them, well, what can I say? This is only America, right? And pimping ain't easy, but what do? We allow it to happen 24/7. So I'm going to end now and get some rest and I'll be back. Most likely, I'm just going to be back.